Appellate Court is now back in session. This is the 1030 case, AC number 43420, City of Hartford Police Department versus the CHRO. We are conducting this hearing on the Microsoft Teams platform. The first order of business is to have everyone introduce themselves, starting with the judges and then counsel for the appellant and then counsel for the appellees, so that we can make sure that everyone can hear and see each other. I'm Judge Prescott.
Good morning, Judge Clark.
Good morning, Judge DiPentima.
Good morning, Daniel Krish, counsel for the plaintiff appellant.
Good morning, Michael Roberts, counsel for the Commission on Human Rights and Opportunities.
Good morning, Attorney James Sabatini for Mr. Fan.
All right. I think everyone can hear and see each other. Just as a housekeeping matter, just please to make sure that you mute yourself when you are not addressing the court, so that it cuts down on ambient noise. If we were to lose your feed sometime during the argument, just try and get back in. We will suspend the argument until we're able to reconnect with you. Another housekeeping matter, I understand that the appellees have agreed to split their 20 minutes equally. Is that correct? Okay, both are indicating yes.
Correct.
You all should have received instructions on the manner in which we're conducting this hearing. If you have any questions about those instructions, please let me know. Also, please understand that we are live streaming this argument on the Judicial Branch's YouTube channel. So if this case were to involve any protected information, which I don't believe it does, but if it did, please be careful not to disclose that information. Attorney Krish, are you ready to go?
Yes, Your Honor.
Okay. Would you like to reserve any rebuttal time?
3 minutes, please, Your Honor.
Okay. And I will hold up a sign when you have 2 minutes left.
Thank you.
Thank you.
May it please the court, I'm Daniel Krish. I'm counsel for the Hartford Police Department. Your Honors, the trial court improperly upheld the CHRO's decision that discriminatory animus caused the department to terminate Koa Fan, and that its legitimate non-discriminatory reason, his dishonesty, rudeness, poor attitude, and unprofessional demeanor, was a pretext. The defendant's case boils down to a few stray remarks by a non-decision maker and a heap of speculation to connect that to the decision to terminate Mr. Fan. Settled precedent makes it clear that is not substantial evidence. So let's start with the causation issue. The Kessler incidents, those two incidents, are not substantial evidence of causation because he played no role in the decision to terminate Mr. Fan, and the supposed nexus between him and the decision mixes a logical fallacy and conjecture. It's important to start with the fact that we're only talking about Sergeant Kessler. Mr. Fan admitted at the CHRO hearing that nobody else in the entire police department or the city of Hartford treated him differently because of his Vietnamese ancestry. And yet, Sergeant Kessler wasn't involved in the decision to fire him, did not conduct the performance evaluations that led to his termination, did not conduct either supposedly biased or flawed investigation, was not a part of the taser incident, and his memo to Lieutenant Bergenholtz, which the trial court erroneously relied on, actually recommended that the department simply retrain him, not that it terminate him. There is no evidence in the record to suggest that Sergeant Kessler's bias tainted the independent decision to terminate Mr. Fan.
Attorney Krish?
Yes, Judge DiPentima.
Just to clarify, so you're not challenging the court's and the referee's determination that he was biased?
Correct. We're not. He denied it, but there is substantial evidence in the record of those two incidents where he made comments derogatory about Mr. Fan's Asian ancestry. But there has to be a connection because he's not the decision maker. And he could have
talked to the decision maker, and wasn't there evidence that there was some communication with others about this behavior on Mr. Phan's part?
Well, first, I think it's interesting you use the word could have, Judge DiPentima, because that's the whole problem with the basis for connecting Sergeant Kessler to the decision to terminate him. There is no actual evidence of it. First and foremost, every police officer who wrote a negative review of Mr. Phan, who wrote a memo about Mr. Phan, testified and denied that Sergeant Kessler influenced their decision in any way. So even if the referee disbelieved all those witnesses, it can't infer the opposite from it. It can't infer that he did influence it.
And I think you make, and I'll be quiet after this, but I think you make the argument that the temporal aspect of the comments and the adverse decision is not enough to show causation.
Indeed, because it's just post hoc ergo propter hoc. So the Kessler incidents happen. He gets some, not his first, but he gets some unsatisfactory marks on his daily observation reports after that. Then 4 months later, the decision is made to terminate him. That temporal sequence does not constitute substantial evidence. And in our brief, we discuss cases, employment cases, where summary judgment against the employee is affirmed despite that sort of temporal sequence. And those are actually the three cases that we discussed. This is 17 and 18 of our brief. Those are actually retaliation cases, where sometimes temporal sequence can be some evidence and still they affirm summary judgment. Yes, Judge Clark.
Well, I was going to ask, so in this case, the referee seemed to have inferred that the circumstantial evidence, the temporal, as you would say, circumstances were sufficient to give rise to an inference. Were there cases in your brief where that sort of determination was actually reversed as being not enough, as opposed to a fact finder said, for him or herself decided it's not enough and they were affirmed?
So there are not employment cases in our brief where the fact finder made that determination and it was reversed. There are other cases in our brief just dealing with post hoc ergo propter hoc to prove causation where that happens. The employment cases in our brief, summary judgment was granted. The trial courts, they're all federal courts, said that by itself is not evidence of causation, and a federal appellate court upheld that decision because timing by itself, that sequence by itself, doesn't prove causation. The other, I think, important point here is most of the cases in our brief, both the Connecticut cases and the federal cases, are on summary judgment, like Feliciano and Alvarez, the two key Connecticut cases we discuss. It's important to note that the substantial evidence rule is not quite as forgiving as summary judgment is to the non-movement, right? On summary judgment, you only draw the inferences that favor the non-movement, whereas the substantial evidence standard requires the fact finder to draw all inferences that the evidence reasonably supports, regardless of whom they favor. There's a section in our brief, we talk about the cases that you can't pick and choose, right? If there's evidence there that reasonably supports an inference, you have to draw it, and we can't just rubber stamp a decision that doesn't do it. But here, right, it's all the tying Kessler's bias to any decision maker is all speculation. Right? First and foremost, right, the trial court, right, said that the nexus is that the package that went to Chief Roberts had Kessler's memo in it. That's not true, right? The CHRO basically concedes that in a footnote in their brief. It had Sergeant Yurgo's memo about the taser incident in that package, not Sergeant Kessler's memo. So that is not a nexus to link them. Kessler complained about Phan to a couple of sergeants, right? But that by itself does not establish that some influence over their reports was caused by his complaints about Phan, right? Mr. Phan had unsatisfactory ratings both before and after the two incidents with Sergeant Kessler.
Did any of the other sergeants have decision-making power with respect to personnel matters like this?
No, they did not have decision-making power. Ultimately, the decision-making power is with the City of Hartford's Human Resources Department, but the two people in the Hartford Police Department who were involved in the chain of decision-making to recommend termination are Lieutenant Bergenholtz, who compiled the package and made the recommendation to Chief Roberts. Those are the two people. Those are not people with whom there was communication, except that Kessler's memo did go to Lieutenant Bergenholtz. Right now, remember, in that memo, Sergeant Kessler recommended retraining, not that Mr. Fan be fired for the confrontations that they had. And that happens in February 2011. In April and May 2011, Lieutenant Bergenholtz, who's the commander of the police academy at the time and is responsible for monthly performance evaluations, gives Mr. Fan acceptable ratings, overall ratings, based on his daily observation reports. It's not until June that the decision is made to recommend termination, and that is based mainly on his dishonesty as a result of the taser incident, which is discussed a lot in our brief, and which the referee spends a lot of time focusing on a completely irrelevant issue, right? As did Mr. Fan in assessment. That's whether or not he should have fired the taser. Right? That's not the issue. Right? The issue is that right after the incident, Sergeant Hugo asked him if he heard the order to fire the taser. And at first he said no. And then when Sergeant Hugo said, well, these other two officers, detectives who were there, said they ordered you, then he said, oh, yes, I did hear them, but I didn't think I had a clear shot. And if you look at Sergeant Hugo's memo, right, which is in our appendix, pages 147 to 48 of our appendix, right, Sergeant Hugo distinguishes between those two things in his memo. And this memo was in the package that went to Chief Roberts. He says that whether or not he should have fired the taser, use of force, that's something just to retrain him on. That's something he can go get more training on proper use of force. But his refusal to admit an error in judgment and his dishonesty when I confronted him with other officer statements, that goes beyond the police academy. That goes to his fitness to be a police officer. That happens in early June. That is the straw that breaks the camel's back, because it falls into a pattern of dishonesty with respect to Mr. Fan. And I won't belabor all of the cases, but there are a mountain of both federal and some Connecticut cases in our brief, right, dealing with similar fact patterns, dealing with claims of bias, all decided on summary judgment. And some have facts that tie the biased individual much more closely to the decision-making process. So, and I'm definitely going to mispronounce this name, but the Raja, let's just call it the Raja case. It's a very long name that I don't want to mispronounce. A district court case decided by Judge Bryant. You had the chair of the department and the chair of the evaluation committee at Central Connecticut, both of whom made biased remarks about the plaintiff's Hindu ancestry. The decision maker read their evaluations, right, and still summary judgment was granted no causation, because there was other materials on which the decision maker relied as well, and the decision maker made an independent assessment. Right? So here, even if the fact that the Kessler memo went to Lieutenant Bergenholtz was the person who compiled the package, that's just one small piece of an otherwise independent, thorough investigation based on contemporaneous objective documentation, the daily observation reports, all of which are in the administrative record, key ones which are discussed in our brief and in our appendix. Unless your honors have other questions about that, I do want to talk a little bit about pretext. So it's important, I think, to start off with what pretext is and what it isn't, because it's not just something that's made up, right? It has to be something that's made up to mask discrimination, right? The employer's actual motive has to be bias, right, for there to be a pretext. Otherwise, even if you have evidence of a flawed investigation, a skewed investigation, right, some biased individuals, right, unless the true motive was bias, then the cover-up isn't pretext under employment law. I think the clearest case of this is the Siddiqui case, the 11th Circuit case we discussed in our brief. Again, affirming summary judgment against the employee. assuming that there was a ham-handed investigation, assuming there was discriminatory animus, assuming that the employer gave false reasons for extending the plaintiff's leave before firing him, all of which the 11th Circuit said that was clearly pretext for something. But we are still affirming summary judgment because there's no evidence that it was pretext for discrimination, right? Which is what the law requires. And in our brief, we discuss a whole host of other examples where you could have a contrived justification. That's the Shaw case. You could have a biased supervisor referring somebody to HR for an investigation. That's the Matias case. You could have a obviously mistaken premise for the supposedly legitimate non-discriminatory reason. That's the Brown case. You could have a flawed investigation. You could have the deliberate choice in an investigation not to talk to the employee or not to talk to witnesses the employee asks you to talk to, right? All of those things do not, as a matter of law, because these are all summary judgment cases, establish pretext, right? In this case, right, what was this a pretext for? Right? Kessler's not a decision maker, right? So there's no need to cover up a few stray biased remarks in the way that there might be if the decision maker was biased, as happens in some cases. They're 4 months earlier, and the department had contemporaneously documented Mr. Phan's problems from the beginning of his tenure as a probationary police officer to the end. Right? I think the closest case actually is the Alvarez case this court decided in 2019, where there was assumed bias on the part of the chief of police in Middletown and one of the detectives, but no pretext as a matter of law, because the department documented the officer's performance issues in contemporaneous daily observation reports and in memos. Unless your honors have other questions or want to ask me about the remand issue, I'd ask the judgment of the trial court be reversed.
Attorney Krish, is it, in your mind, is it easier for a plaintiff to establish a mixed motive termination than a pretextual termination?
Yes, it is, Judge Prescott, because of the burden shifting or lack of it, right? In the McDonnell-Douglas model, the burden stays always on the employee. So it becomes their burden to prove pretext, right? In a mixed motive case, when you get to that third prong, the burden shifts to the employer to prove that there was not pretext, right? And that plays out very clearly in this case. You know, look at how the referee in her remand decision viewed the explanations for the taser incident and the hat investigation. Right? She, in my reading of her decision, she did not believe the sworn word of a bunch of Hartford police officers, and instead of having the burden be where it should be on Mr. Phan, right, to prove that this was pretext. So that is the difference. Mixed motive is a more employee-friendly test.
Okay.
So I just have a follow-up on that, if I could. So is it your position in your third issue? I was a little confused by that. So you're saying that the referee should not have mentioned mixed motives in her remand, in her decision on remand?
It's not that she just mentioned it, Judge DiPentima. It's the fact that she performed analysis under it again, and it's the amount of times that she mentioned it. If you look at pages 11 to 12 of our brief, it summarizes her attitude towards the trial court's ruling that she had applied the wrong test. She defends her original ruling. She talks about the mixed motive test. She applies the analysis under both of them. She says several times under either test, the result is the same. You know, you can't, you know, pry open a fact finder's brain to see what they're really truly thinking. But what she said, I think, you know, suggests disregard of what the trial court told her the law was. Otherwise, why do all of that? Right? If she had just said in her intro, you know, there's two tests, there's mixed motive, the first time around I applied mixed motive, I have now been told to apply the other test. That would be one thing, but that's not how her decision reads. And again, pages 11 to 12 of our brief have a long summary of the degree to which she thumbed her nose at the trial court.
To your prejudice.
To our prejudice, yes. Now, the court only has to reach this issue, of course, if you disagree on the first issue, because if there's either no substantial evidence of causation or pretext, you don't have to decide whether she applied the wrong test.
Thank you.
Thank you. I'll reserve the remainder of my time for rebuttal. Thank you.
All right. I don't know who intends on going first. Attorney Roberts.
Thank you, Your Honor. My name again is Michael Roberts. I represent the CHRO. Your Honors, this appeal should be dismissed because it is simply an attempt by the plaintiff to obtain plenary review of factual findings and credibility determinations and the reasonable inferences drawn therefrom through the lens of a legal issue. The plaintiff has tried to minimize what is the definitive case for its primary issue, which is Board of Ed of Norwalk versus CHRO. That is the case here, and the plaintiff has relegated it to essentially a CF in its brief. It hasn't even mentioned it here today. And in that case, Your Honors, the Supreme Court made clear that while disbelief of an employer's explanation may not be sufficient on its own to establish a prima facie case, it is sufficient in conjunction with an otherwise proven prima facie case to show that the employer's explanation is pretext and that therefore the ultimate question of discrimination may be answered for the employee. In putting that decision solely in a passing CF citation and not mentioning here today, the plaintiff is essentially putting an elephant in a mouse hole, because that is the case that decides the pretext issue here. It's not simply that the referee below heard the witnesses offered by the plaintiff and in isolation determined that for disbelieving that testimony that she should find in favor of the plaintiff. I see a question from Judge Clark.
Attorney Roberts, who is the decision maker from your perspective in this case?
Well, I would say that it's you mean at the Hartford Police Department? Well,
whoever made the decision to terminate the employment. I don't know where
it would be the chief based on the evidence that we've seen, Chief Roberts.
And did the referee find that Chief Roberts intentionally created a pretextual explanation for the termination, or that somehow he was unwittingly infected by the fruit of the tree, which was Sergeant Kessler? Isn't that essentially the theory of the referee in this case?
That's correct, Your Honor. That it all comes down to Kessler. And while the plaintiff has argued that Kessler really didn't have a role at all in the ultimate decision-making process, they're essentially trying to have it both ways. Do you agree also with Attorney Krish that the memo from Kessler never made its way directly to the decision maker? The record shows that does not show that the memo itself was included in Bergenholtz's letter, but Bergenholtz references those incidents in his memo to the chief, which would suggest that the chief was aware at the very least that they had occurred, or that Bergenholtz clearly was relying on that in making his ultimate determination to the chief.
So in a nutshell, really, the referee's findings and theory of the case was essentially that Kessler was motivated by racial animus, and following the altercation, I guess is what you might call it, or maybe there were two altercations between Fan and Kessler. Kessler went about essentially making sure that those who were responsible for supervising Fan would find a way to ensure that when it came time to do the review during the probationary period, sort of rig the game essentially, so that the unwitting decision maker would wind up terminating the employment. I mean, that's essentially the gist of it, right?
That's essentially it, Your Honor. Yes.
And the evidence for that is I guess the trial court's disbelief of Kessler's colleagues who claimed they weren't infected, and I guess the temporal circumstances between what had been happening with fans' reviews and what happened shortly thereafter. I mean, that's essentially the whole case here, right?
Essentially, that's it, Your Honor. And you're right. You can almost contact trace Kessler's interactions with other staff members and the way that they began to change their expressed opinion of Fan in this process. If you look at the history of the daily observation reports, Fan was on an upward trajectory. And then the incidents with Kessler happened. And then you have sergeants that are changing their views on that. Yes, Your Honor.
So what if it really was a coincidence, though? I mean, so what if, I mean, is it just the case that if someone's doing relatively well or satisfactory, and then at some point stops doing well, satisfactory, the employer's just plain out of luck because someone along the line made some sort of racially discriminatory comments? I mean, that's it.
Well, no, Your Honor. Those are inferences that could be drawn by a fact finder. Ultimately, a fact finder could look at this and say that, this seems too loose. They could have credited the determinations of the arguments of the plaintiff's witnesses. They could have found that the reason offered by the plaintiff was a legitimate reason and not pretext. That is the power that's afforded to the trier of fact. But as the Connecticut Supreme Court noted in Dufresne versus CHRO, which we cited in our brief, the possibility of drawing two inconsistent conclusions from the same body of evidence does not mean that there has been an error of law in that. And that's the case here. The referee was empowered to look at the overall circumstances, to look at the way that Kessler began to speak to, in his own admissions by his memo, speak to the other sergeants. Either Kessler was not involved at all in the decision-making process here, in which case he went out of his way then to discuss his views with Bergenholtz, with the other sergeants who were making their reports, anyone he could talk to, or he was involved, in which case his memos and his comments, his conversations with other officers are even more directly implicated in the decision-making process here. Ultimately, the referee not only had the testimony of the other officers, but she had Fan's testimony. She had the documentary evidence, and so she was able to credit the evidence that went against the Hartford Board of Ed, and all told, based on the entire body of evidence, was able to draw inferences, make her findings of fact, and assess the credibility of the witnesses and the evidence. And so we don't have an instance here like
Attorney Roberts, did Chief Roberts testify at the hearing?
I don't believe that he did, Your Honor.
But you concede he was the decision maker.
It would seem yes, Your Honor. Ultimately, based on the long and short, I agree with Attorney Krish that.
Why the qualifying? It would seem yes.
I agree with Attorney Krish that ultimately the technical decision making fell to the Human Resources Department, but for all intents and purposes, he was the decision maker here.
I thought there was testimony that the Human Resources Department terminated him on the basis of Roberts' recommendation.
That's precisely right, Your Honor. So for all real purposes, they just adopted his recommendation. Technically, they had kind of the final decision issue here, but it was really Chief Roberts's recommendation that was the deciding factor. Briefly, Your Honors, I wanted to touch on the remand issue. I know that my 10 minutes is coming to a close. I wanted to just briefly touch on that. the plaintiff has not pinpointed what exactly in a decision on remand is too much or too little to satisfy the appellate decision here. I think that there's a quotation on page 32 of the plaintiff's brief that is really telling about what the plaintiff's issue with the remand is, and that is its quotation that decision on remand reshuffled the cards after the plaintiff was dealt a winning hand. I think after the initial appeal here, the plaintiff felt that the outcome should be in its favor on remand, but that is not what Judge Schumann's remand directed. The remand ordered the application of the pretext analysis in lieu of the mixed motive analysis. But just because the referee mentioned what she had done before does not make this error. By both the spirit and the text of the remand order, the referee adhered to it. She may have still found against the Hartford Police Department and in favor of Mr. Phan, but that in and of itself is not a violation of the remand decision. Ultimately here, Your Honors, again, we have quite a bit of discussion of the substantial evidence, which is really the standard for factual determinations, not the legal determinations here.
Right. Attorney Roberts, you're out of time.
Thank you, Your Honor.
Okay. Attorney Sabatini.
Been doing this for the last year, and I'm still forgetting to unmute myself. I wanted to devote my 10 minutes to further addressing the causation issue, including transfer intent. Let me begin by pointing out that the hearing referee had both general and specific evidence of Sergeant Kessler talking to his fellow sergeants. Generally, Kessler and his fellow sergeants talked to each other and socialized outside of the workplace. Specifically, Sergeant Kessler talked to several sergeants about Officer Phan. The memos criticizing Mr. Phan's character and performance started immediately after Kessler commenced his supervision of Officer Phan. Given that Kessler socialized with the other sergeants and talked to the other sergeants at work and outside of work, given that Kessler admitted that he talked to other sergeants about Officer Phan, and given that the negative memos about Officer Phan's behavior and performance commenced immediately after Kessler began supervising Officer Phan, the trier of fact, in this case, the hearing officer, had ample evidence to conclude that it was more likely than not that Kessler, yes, Your Honor.
What was the nature of the evidence with respect to Kessler's communications with the other sergeants, and what specific remarks were made one way or the other by Kessler to those other sergeants?
What specifically was discussed, the hearing officer made a reasonable inference that what was discussed was negative, because the negative memos that began to be issued to Mr. Phan began shortly after Sergeant Kessler began supervising him. Yes, Judge Clark.
But what was the nature of the evidence with respect to the establishing that there were, in fact, conversations between Kessler and the sergeants?
Because Sergeant Kessler admitted to talking to other sergeants about Mr. Phan. And shortly after Sergeant Kessler began supervising Officer Phan, the negative memos began to be issued. So the hearing officer had ample evidence to conclude that it was more probable than not, or more likely than not, that Sergeant Kessler communicated his negative opinions about Officer Phan to his fellow sergeants, and they in turn commenced their negative write-ups of Officer Phan, which ultimately made its way in that package of materials that the chief of police relied upon when deciding to terminate Officer Phan's employment. Yes, Judge Prescott.
317, let me ask you this hypothetical. Assume for a minute that Kessler, and I think we have to, had racial animus towards Mr. Phan, and therefore spoke negatively about Mr. Phan to the other sergeants, but in those conversations did not indicate in any way to the other sergeants that his negative feelings about Mr. Phan were in part or in whole based upon his racial animus. Is that enough for your client to prevail?
Yes.
Why?
And applying the transfer intent theory is necessary in order to prevent an employer, such as the city of Hartford, from avoiding liability for unlawful discrimination. In this case, they have a sergeant in their ranks who, by the way, had a history of racial bias, who displayed his racial bias towards Officer Phan. That racial bias influenced Sergeant Kessler's review of Mr. Phan's performance and his perception of his character. He broadcasted his negative views of Officer Phan to other sergeants, who then, in supporting their fellow sergeant, wrote up the negative write-ups, which ultimately led to the termination. The transfer intent theory exists to prevent a situation where an employer avoids liability. Sergeant Kessler's bias and the actions he took on that bias lit the fuse that culminated in Officer Phan's termination. Yes, Judge Clark.
But in order for that theory to sort of play out in this case, something must have been done, even if it weren't, the intent to discriminate of these other people. They must have done something other than simply observe and report factual matters. So what is it we're saying about the intent of the other sergeants here? What is it that we're inferring they did and why? What was going on in their minds and what did they ultimately do? They lied, essentially. And why? Because Kessler, without disclosing to them his true motives, basically said, I don't like this guy, let's take him out?
Yes. Yes, Judge Clark. These sergeants. Yes, Judge. Yes.
So am I correct that this Kessler had a history of being racially discriminatory, had a racial animus before this?
Yes.
You said history?
Yes.
So everyone in the police department presumably knows this. And you're saying that his reporting on bad stuff about your client, based on this animus, no one else has to have any discriminatory intent for the police department to be held liable, even though he's not a decision maker. There seems to be a gap. That's why I'm just puzzling over that.
Okay. Judge, going back to the transfer intent theory. The theory works when there's proof that the decision maker, whether knowingly or unknowingly, relies upon the negative information that came from the supervisor that harbored the discriminatory bias. So in other words, if the chief in the package of materials, if that packet didn't include Sergeant Kessler's materials, then the transfer intent theory would likely fail, because the negative information from the discriminatory supervisor never made its way to the chief. That's not our case.
But I thought you said in response to my question that these other sergeants who were themselves unwittingly influenced by the racial animus provided negative information to the chief. So how far does this chain? It seems to me that now you're saying the chain has to be direct. The decision maker has to have been directly infected by the animus of the actually discriminatory actor. So I'm a little confused now about the role of these other unwitting or maybe sergeants that collaborated for reasons other than racial discrimination. I'm just trying to understand how this.
My view of it is that since in the packet of materials that the chief of police was provided with included Sergeant Kessler's materials, that evidence is sufficient to establish the transfer intent. Whether or not the other sergeants that provided the negative information were aware of Sergeant Kessler's history of discriminatory animus or racial bias or not. I want to take the last a minute or two to discuss why the Jones case is distinguishable from this case. And very briefly, in Jones, the trial court found that one of the Mr. Jones' supervisors, Ms. Goldberg, harbored no discriminatory animus, and when she provided negative information to the decision maker, none of that information that she provided came from the former supervisor that Mr. Jones had, Ms. DeBrito. That's the person that harbored the discriminatory animus. And also that Goldberg did not rely upon any information that came from Supervisor DeBrito. Getting back to Judge Clark's question to me, in this case, there's evidence that the other sergeants, when they began their negative write-ups of Mr. Fan, relied upon the negative information from Sergeant Kessler. Also in the Jones case, what I also like to note is that in that case, the Department of Children and Families had conceded that Supervisor DeBrito harbored a discriminatory animus. The trial court found otherwise, and implying that substantial evidence test, this court did not, this court gave the appropriate deference to the trier of fact. I think I've run out of my time.
You have.
Thank you, Your Honors.
Thank you. Attorney Chris, rebuttal.
Thank you. First, there's no such thing as the transferred intent theory. Right? Transferred intent was the standard Connecticut applied before cat's paw liability was clarified by the Supreme Court. The CHRO argued for cat's paw liability. That's where a biased subordinate manipulates the ultimate decision maker. They argued for cat's paw liability. The referee didn't find cat's paw liability. The one Connecticut case that talks about transferred intent is the United Technologies case, which we discussed in our reply brief. But it's important to look quickly at that, right? So you had a biased supervisor whose intent was transferred to the manager who fired a female employee. Why was it transferred? The biased supervisor wrote a report about an altercation between the female employee and the male employee that led to the firing. That's not this case. The bias supervisor listened to the male employee side of the story, refused to hear the female employee side of the story. That's not this case. He directly communicated his slanted version of the incident to the manager. Not this case. He recommended that the manager fire the woman. That's also not this case. In fact, the only biased person, and I don't want to belabor this, but Sergeant Kessler recommended that Sergeant Fan be retrained, not that he be fired. But the only Connecticut case with, yes, Judge Clark. Judge Clark, you're on mute.
My wife wishes she had one of those for me. So, following up on a question from Judge DiPentima to Attorney Sabatini, what did the record say about when Kessler had been disciplined in other circumstances and the extent to which that was substantiated or known throughout the department in terms of the chronology?
There was one complaint about his racial bias before this. It was unfounded after a department investigation. Everything else postdates this, the termination of Mr. Fan. Now, we concede, because the referee found it, that he made biased remarks. But he's not a decision maker. There has to be something that connects him to the actual decision. And Attorney Sabatini said a number of times that all of the negative reviews commenced after the Kessler incident. That's not true, right? In November and December of 2010, Officer Fan received unsatisfactory ratings for attitude, and that's found by the referee. It's page 38 of our appendix. Right. So it's not as though he was on this upward trajectory and doing great, and then Kessler intervened, and then everything went downhill. Right. He had problems before Kessler. He had problems after Kessler. He had a period when he did well, and then the taser incident happened. Right. And that was the straw that broke the camel's back. If I may, just to bring Board of Education out of its mouse hole. The reason why Board of Education is different is that the appellant didn't argue that there was no prima facie case of causation. The only issue in Board of Education was pretext, right? Here, they want to assume the first part of what Board of Education says is enough, but there's absolutely no evidence of a prima facie case here. Yes, Judge Prescott. I've got myself in trouble by going over my time.
That's okay, but you are out of time.
Oh, well, thank you. Yes.
I want to thank you all for a very well presented case. Appreciate it. Hope we'll be seeing you back in the real courtroom shortly, and we'll take the matter under advisement, stand in recess until the 11:30 case. Thank you.
Thank you, Your Honor. Be well, everyone.
Thank you, counselors. Good morning.